Brian Padayachi, the senior investigator from IDAC, is back before the Madlanga Commission today as the inquiry continues to examine serious allegations involving senior police officials. Before we continue, please kindly subscribe to our channel, like and comment your opinion below. His return comes just a day after making a remarkable claim that has sparked widespread debate. Padayachi told the Commission that SAPS Brigadier Dineo Mokwele was arrested and charged over a crime investigators believed she might commit in the future, rather than for an offence they say had already taken place.
We've got more arguments in the Western Cape High Court, which will be heard today. This is as the President, Cyril Ramaphosa, makes an attempt to stop the parliamentary impeachment process against him. Zoleka Kodashe, closely following those developments, joining me now live from there. You've shared a number of different perspectives, Zoleka, since the start of this morning around what's in it in the long term and the fate of the impeachment panel, the opposition and the clash between them, their legal response to the President's bid this morning. What could we expect to unfold immediately when court proceeds this morning?
Well, what we expect to unfold, Iman, is that we are scheduled to hear the reply from the President's legal counsel, who will be responding to some of the opposition that he has faced in advancing the President's argument. You'll remember that the President makes a number of arguments. Chief among them is what he says is the panel's misinterpretation of its mandate, in that in conflated prima facie evidence or prima facie case as opposed to the sufficient evidence that it ought to have found that would have triggered the impeachment hearings against him. But that's not the only contention that is made by the President. He also says that there was a failure by the Section 89 independent panel to actually consider whether in the the alleged conduct that relates to the events on his Phala farm in 2020 were done in bad faith. And now he points us to Section 89, subsection 1 of the Constitution. You'll remember that that prescribes or stipulates the 3 instances in which a president or sitting head of state can be impeached. 1 is if they are found to be guilty of serious misconduct. 2 as if they are found to have committed a serious violation of the Constitution or the law, and 3, if they have an inability to perform their functions of office. Those are the 3 grounds upon which a president, a sitting head of state, can be impeached. But what the President then says is that when you look at the rules of the National Assembly, they put flesh to the bones, in that they highlight or accentuate what serious misconduct is, as well as what constitutes a serious violation of the Constitution or the law. And what he says is that in terms of the definition of serious misconduct and a serious violation of the Constitution and the law, which are impeachable offences for a sitting head of state, that means that the President ought to have acted in bad faith, knowingly and maliciously. And so he contends that if there is a finding against him, then without the Section 89 independent panel inquiring as to whether he acted in bad faith, then that cannot constitute an impeachable offence. Of course, opposition parties coming out quite strongly in opposing that particular application or arguments that has been made by the President in looking at what the actual report found insofar as it relates to the President's conduct. You remember that it found that he may have prima facie violated particularly Section 96 of the Constitution, that stipulates that a member of power, or rather a member in the executive and cabinet, cannot perform any paid work, because this would bring about a conflict of interest. Let's just take a listen to what Advocate Mfesanika Siboto had to say. And of course, he represents the economic freedom fighters.
A dictionary meaning is intent to deceive. You then go to 72. The correct approach to determining the existence of bad faith is therefore one that recognizes bad faith exists only when the office bearer acted with a specific intent to deceive. Put differently, the panel's view on the basis of those principles say what bad faith is an intent to deceive. So to the extent you find in the report words to that effect or akin to it, then you must accept that dealing with bad faith. What you then find in the report itself, these are the findings of the report. It says was deliberate intention, read bad faith. The president abused his position, read bad faith. There was more currency in the sofa than disclosed, read bad faith.
Therefore, Iman, it is the contention of some opposition parties that the president's argument that the Section 89 independent panel did not consider whether he acted in bad faith in relating to his conduct on his Phala Phala farm in 2020 does not hold any water. Of course, we expect that the president's legal counsel will be responding not only to this, but the plethora of other opposition submissions that have been made in this urgent application in which the president seeks to interdict the commencement of impeachment proceedings against him, Iman.
So, Qadashe, thank you, and we'll watch those developments closely. And we have a discussion with Lawson Naidu from KSAC about some of the constitutional issues that are raised.
The statement immediately raised questions about the basis of the investigation, with many wondering whether the arrest was supported by sufficient evidence or whether investigators acted too early. Today's proceedings are expected to focus on Padayachi's testimony, with commissioners likely to question him further about how the investigation was conducted and the evidence that led to those conclusions. The Madlanga Commission continues to hear testimony from key witnesses as it investigates allegations of misconduct and possible abuse of power within law enforcement. What do you think about this latest testimony? Share your opinion in the comments below. If you enjoy factual South African news updates, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss an update.
Doesn't happen in criminal matters that way.
Fair enough, that I accept. But that's not the point. The point I'm making is that the police in their investigation will come to me and say,
yes, of course.
Yeah. So I'll give my version. Even the NPA, by the way, will also look into my statement before they make their decision. But I'm making a different point, Justice Lafrance, which is this, that Mr. Tengov is completely mistaken in conflating the prima facie assessment that is done by the Speaker, which is a mechanical exercise, that's the NPA example, to the one that is done by Chief Justice and a judge and a senior counsel, which is a completely different exercise. The fact that semantically you use the word prima facie, even for the NPA, doesn't mean it's doing the same job as the court. That's really the point I'm making. In other words, because the argument is supposed to be a rhetorical question. Well, if they are doing prima facie, then the Speaker is also doing prima facie, then what's the point? But these are two or three different stages. And the proof of that is here. Mr. Tengov's argument actually turns against himself, because he says, rightly, in the rules to do with the public protector, there it says plainly the panel must do a prima facie assessment. But in those rules, it also says that the Speaker must do the prima facie assessment. So that's a non-argument. It turns against him because it shows exactly the point I'm making, that those are different standards that are being applied. So, okay, let's remove that point.
No, before you move that point.
Sorry.
So, do I understand you correctly that the panel must establish what on whether sufficient or prima facie evidence if there's a case for the president to answer?
That's all. With the greatest respect, this distinction between sufficient evidence and prima facie evidence is absolutely manufactured. The Constitutional Court made it clear that those two things are synonymous. But
you must agree the way the Speaker looks at it must be different from the way the panel must evaluate it.
No, absolutely. No, yes, Justice Lafrance, let me be very clear. There are two distinctions that we are making. The one that we are making now, which is the two prima facies of the speaker and but now I was addressing the other distinction between sufficient evidence and that's the one that I'm saying is artificial. And the reason why it's artificial is that in the famous paragraph 139, you see that the Constitutional Court uses these terms interchangeably or in the same breath, so to speak. It says, however, where the panel concludes that sufficient evidence exists to disclose a prima facie case, and that's the exact question that the very first question Justice Lefranc put this morning was about this, and it was not answered with respect. Whether isn't really this thing much ado about nothing? All they are saying is sufficient evidence to disclose a prima facie case. If the Constitutional Court, no lower than the Constitutional Court, uses this in the same breath, who are we to say, no, this one is in the West, this one is in the East? It's not. And to cut through all those semantic debates, we come back to what we are saying, Justice Lefranc, which is all, and this court, both in EFF2 and in this case, they have said that all that really is needed is there a case to answer. So let's not bother with these niceties. Is there a case to answer on the Pala issues? Yes or no? If there is, go to the committee. If there isn't, go home. It's as simple as all that. And Mr. Tengo says that paragraph 76 of the report, he praises it of eloquence. And you'll find that at 001-131.
Paragraph
76, my lord.
Of
the report.
Of the
report, sorry. Yes. Of the ICE report. It's at page 131. Now you'll see that.
Brian Padiachi, IDAC senior investigator, is back before the Madlanga Commission today, a day after telling the inquiry that SAPS Brigadier Dineo Mukwele was arrested and charged over a crime investigators suspicion that she might commit at some point in the future. Sianda Ngobo is live for us at the Commission. Sianda, we can begin with that admission, which drew some tough questions from commissioners on how you prosecute someone for conduct that hasn't yet happened, and no doubt reflecting as well on some of the more dramatic moments in the Commission yesterday. Good morning.
Good morning. Absolutely. And to quote the Commission's chairperson, that's quite a quantum leap in logic, isn't it? How do you charge someone, arrest them, and have them face the country's courts on a basis that you believe that they will commit a crime in the future? So what is it about the appointment of Dineo Mukwele, who, by the way, responded to an advert that was put out there for her to apply for the post? What is it about her appointment that led IDAC to believe that this one formed part of the capture of crime intelligence on the part of Dumisani Khumalo, but also that this was a matter that required criminal charges to be held against them and not it being referred to HR, for an example? The other aspect that came out quite sharply yesterday was the fact that perhaps the Public Service Commission could have dealt with this matter. So what is it in Fadiel Adams' affidavit that told or gave an indication to someone who is a senior investigator within IDAC that this was a criminal charge that needed following up on? This is the kind of logic that it would seem the commissioners believed was flawed. In fact, here's Co-Commissioner Sesi Boloy on this very aspect.
You formulated a charge, you got a warrant of arrest, you got people arrested, you have people appearing in court, and continue to do so on the basis of something that you say, and rightly so, fairly so. You say, well, we don't know, maybe in future she was going to do that. How does that, for a seasoned investigator, how does that sound right? As you say it, we don't know. Maybe in future she was going to do that, and you've taken all these drastic steps that have a consequence on people's lives and have had a consequence. And you sit there now, many months later, you say, well, we don't know. Maybe she was going to do it in future. It cannot be right that that's a basis on which you went and instituted this prosecution and got a warrant of arrest. That's precisely the problem with this.
In fact, the use of the word capture is also not something to be taken lightly, Iman, given how the words capture and the era that we've come out of, which subsequently saw even the Zondo Commission of Inquiry. It's not a word to be used lightly to accuse someone like Dumisani Khumalo of capturing in crime intelligence. It's a question that Brian Pariachi struggled to respond to insofar as how exactly was this capture allegedly going to take place, and what role would have Brigadier Dineo Mukwele played in this alleged capture on the part of Dumisani Khumalo, especially because IDAC was formed as a result of the Zondo Commission. Iman, they were going to be looking primarily into the state capture cases, and so if you struggle to even define a capture in whatever context, it begs the question for an institution that hasn't even been around that long, mind you, what kind of other aspects or issues and credibility challenges they may face insofar as the other cases that one, Brian Pariachi, but also IDAC as a whole, as an institution, have opted to chase. Remembering what Pariachi also told us on a previous occasion, that these matters are decided upon by a case intake committee, where prosecutors sit on this committee, and they're the ones who decide on whether or not to proceed with investigating after they would have received a Section 27 referral. And so there are many questions that someone like Andrea Johnson would have to respond to insofar as why this particular matter warranted further investigation and ultimately prosecution, as the matter is still in court but yet to actually stand trial. Iman.
And proceedings kick off at 9:30. Ziyanda, thank you for that wrap of yesterday and setting the expectation for today.
We do a first come, first served basis.
Thank you. It's almost tea time now. All of us were inside listening to the proceedings in court. The president is going to struggle. First of all, they're trying to attack the Section 89 panel report. There is no way the Constitutional Court would have ordered compliance with a defective report. That's a nonsensical argument. The court could only, the Constitutional Court, ordered that the Section 89 impeachment proceedings must be complied with because it was satisfied that the report made sense. We're talking about a report of a panel, a distinguished panel. Chief Justice Noah is an outstanding judge. We all know that. In any event, there is no perfect report in this world. The report itself makes it abundantly clear that it was based on the version of Ramaphosa, which still doesn't make sense. It's a fairy tale, right? So all we are saying is that counsel for Ramaphosa is struggling at the moment. It is very clear from the questions that the judges are asking that he is struggling. Law is really like medicine to some extent. You don't go to a doctor when you have AIDS and hope for miracles. Lawyers are not magicians. They don't do miracles. Ramaphosa has a hopeless case. It's a delaying tactic. He does not want to account. This is the president, as I have said in this morning, who thinks he is above the law. And his argument, the gist of his argument is that he is going to be humiliated. He will be given an opportunity when he appears before the impeachment committee to state his case. He knows he will not survive cross-examination. We will wipe the floor with him. He knows that.